We are recording. Welcome, everyone. Excited this morning to learn about all things consignment with a dear friend of the council, Charles Klein.
Good morning. I'm Charles Klein, the chair of the Fashion Law Practice, Davidoff Hutcher and Citron LLP, a mid-sized commercial law firm about a mile away from the ACC's offices. I want to thank Karen and the Accessories Council for having me today to do this program about understanding consignments. And I thank you for coming both in person and virtually. Before I begin the program, I'm going to talk about what this program will concern and what it won't concern. This program will concern protecting your rights for the consigned merchandise that you consign to a retailer in the US and your right to receive payment on its sale. Secondly, we're going to talk about how you can keep your merchandise out of the hands of the retailer's lender if the retailer defaults on its loan with the lender and the lender seeks to take possession of the merchandise of the retailer and its proceeds. You're making a face, but this has happened. There's a huge case where this happened and nobody did it right. And that's why one of the reasons we're talking about this. All this revolves around laws that are called the Uniform Commercial Code, which are laws that have been adopted in all the states of the United States in same or similar formats. And the lawyers call it the UCC. And if it sounds boring, it's because it is, but it's also important because the UCC governs important aspects of consignment transactions. Needless to say, this is technical legal stuff for which you need the help of a lawyer if you're doing a consignment. And we'll get into that as we go along. So what are we not going to talk about? We're only going to talk about this subject from the perspective of a wholesaler, designer, wholesaler, someone who is selling goods to a retailer. We're not going to talk about the subject really very much from the perspective of the retailer or from its lender, except as it relates to the wholesaler's issues. We're only going to talk about doing consignments for goods in the US, because other countries have different laws and different rules. So we're not going to address that today. We're not going to really talk about outright sales, which I'm going to get into in a moment, other than to contrast the outright sale with a consignment sale, so you understand the basic difference. And we're also not talking about consigning goods to consignment shops. So first, what's an outright sale? An outright sale is the typical sale of merchandise, often in response to a purchase order received from a retailer. And you as the wholesaler ship the goods, you invoice the goods upon shipment, and you're entitled to receive payment on whatever the payment terms are, COD, net 30, net 60, whatever they are, and you get that payment regardless of whether the goods are sold to the customer of the retailer. And retailer can do whatever it wishes with those goods, sell them to whoever it wishes, and you get paid regardless of sale. So the retailer is assuming all the risk that the goods don't sell. Consignment transaction is the reverse of that. In a consignment arrangement, the wholesaler, who's called the consignor, delivers the merchandise to the retailer, who's called the consignee. The wholesaler remains the owner of the merchandise unless and until it is sold to the consumer customer of the retailer, or unless the lender of the retailer is able to take possession of those goods and proceeds, which we're going to seek to avoid going through the process that we're going to discuss. No money is owed by the retailer to the wholesaler, to the consignor wholesaler, unless and until the goods are actually sold. So the retailer likes this arrangement because it doesn't have to advance any money to get this product. It has all these products to sell without having to pay for them in advance. The wholesaler likes the arrangement to a certain extent because it's getting its products out that it might not otherwise get out into the marketplace. And it does that, and they do that to prestigious retailers as well, which would not get to otherwise, that are not going to buy it on an outright sale basis. But there are risks and pitfalls in the consignment arrangement that we're going to talk about. First, there are a few business considerations to think about. If you're consigning goods for a long time with a retailer, are those goods going to become dated or stale? Now, I think that's often not the case in the jewelry area, where goods tend to be sort of more classic designs. They're not, the changing the whim of the season as they are in apparel or some other products, but it's something to bear in mind. Secondly, do you as the wholesaler want to produce a lot of goods for a consignment transaction where they might not sell? And third, something else to consider, and to ask yourself, and again, maybe because consignment's more common in jewelry, it may not be the issue there, but is your retailer financially troubled? Is the reason why they don't want to buy the goods outright from you because they're having some financial problem and they don't have the money to buy your goods? And even though we're going to talk about the process to make sure that your goods never end up in the hands of their lender, if you think that they are financially troubled, I would not consign goods to them in the first place. That's just my advice. That's at least beware of that risk. So at the core of a consignment transaction are 2 or 3 documents that we're going to talk about. The first is a consignment agreement. And that's an agreement that's going to govern the general terms of the consignment arrangement between the wholesaler and the retailer. The second one is a consignment memorandum. You sometimes hear, I'm selling on memo, consignment memorandum, and they are interrelated, often interrelated documents, but they may be separate documents because the consignment agreement itself is going to govern all sort of the general arrangement. And then we're going to talk in a moment about what the consignment memorandum says and when you're going to do that. So when you're dealing with specialty stores and you're consigning goods to maybe a group of specialty stores, you as the wholesaler should write the consignment agreement. And one general piece of advice, though can't always do this, wherever you can control what I can call controlling the document in your business, writing the contract, you should write the contract whenever you can in your general affairs. We can't always do that in life. You lease a space, you're not going to write the lease. There are all sorts of other arrangements where you cannot write the agreement, but where you can, you want to do that. And some people say, well, I'm going to save $1, I'm going to let the other side write the agreement. Well, what happens is the other side writes an agreement that's extremely favorable to them sometimes. And just to get it back to something that's fair midway, you have to spend an enormous amount of time and money to do that. So with a specialty store, I recommend having you do the consignment agreement. And if you're doing multiple consignments, have your form consignment agreement that you work with a lawyer, you send it to the retailer, they may have comments on it, and you get it done that way. When you're consigning goods to a department store, to a Saks, to a Neiman Marcus, they're not going to let you work off your agreement. You're going to have to work off their agreement. But you may want to do a lot of changes try to make a lot of changes to their agreement. I've gone through that process. It's often a very slow, difficult process with them, but you need a lawyer's help to do that because it's a very technical area, as you're going to see as we go along. So here are the important terms and conditions that you need in a consignment agreement, whether you're doing it in your own form or whether you're working off the department store's form. First, that you as the wholesaler remain the owner of the merchandise until it's sold to the consumer. That's key. That's the most important aspect of this. It's your merchandise. 2, that the retailer is going to send you a periodic sales report about goods that are sold. So you know that when your goods are getting sold and what price they're getting sold for. 3, that the merchandise is going to be maintained by the retailer in first-class, safe condition at agreed locations and sold only to consumer customers and not to any other third parties. They can't take your goods and sell it to somebody else who's not going to be subject to the consignment agreement and arrangement. Sell it to their consumers, and that's it. Needs to be clear about that. That they're going to pay you within a specified time period. And that should be a short time period because It's not like you're selling to somebody to the retailer who has yet to receive money for it. When they're going to pay you, they've already put that money into their pocket. They've already been paid by the consumer. So you want that period to be as short as possible. 10 days or whatever after payments received, or monthly, for all the payment, 10 days after the end of the month for all the payments that have been received during the month, but you need a short window period. Retailers try to stretch, the big retailers try to stretch that out, and there's no good reason for it other than wanting to keep your money. The consignment agreement should also say that you can get the return of your goods whenever you wish. It may not be selling. You may have financial concerns about the retailer. You may have a better retailer may have a retailer who wants to buy them outright from you. So you should be able to get them back when you want. You don't want to give, and this is something for the unwary. You see this in the department store forms. You don't want to give them a purchase option at the end to buy your goods. And you say, well, why not? Why, if they're just buying it, why shouldn't I want to do that? And here's the reason. Because at the end of the day, the retailer may then become financially troubled. And so they buy your goods. They're not paying you COD. They're never going to say that they're going to pay you COD. So they've now taken title to your goods. And they may file for bankruptcy. They may go under, and you may never get paid your proceeds. And that money that's supposed to come from them is just a general obligation. It's what we call an unsecured obligation on the part of the retailer, and you're going to be a general creditor if they go bust. So of course, if you want to sell it to them, you could arrange that you could also arrange that they're going to receive title upon your receipt of payment of the money for it. But I would not just give them a general purchase option with some payment down the road. And that's something which, to the unwary, you'd say, well, look, they're buying my goods. Isn't that a good thing? Well, it might be a good thing, but it's something you should work out directly with them and not just giving them an option about it, but you should have to agree to sell it to them. So they also should keep your goods insured and name you as an additional insured on their policy while the goods are in their possession. And then here's another sort of technical issue, but you want to file what's called, this is a technical issue that lawyers know about, what's called a UCC1 financing statement. You want the consignment agreement to say that you can do it. And what is a UCC1 financing statement? What it says under the Uniform Commercial Code is that you're going to put the world on notice that you own these goods and that you have the right to the proceeds from these goods to the extent of your agreed upon wholesale price for the goods, and that they don't, in effect, that they don't belong to the retailer. And that becomes critical vis-a-vis their lender. But you want the world to know that they're your goods. And why do I not want the retailer to do that? Because they may not put the right language for you in it. So they may say they want to approve it, and that's okay. But you want to draft that, and maybe they may be slow in doing it. You have to chase them to do it. You want to control this process. So you should do that.
Charles, when we spoke, you had a story about like this and what could go bad.
Well, we're not up to that yet,
Okay.
but I'm gonna, but we're gonna get up to that.
Yeah,
It's
frightening.
Yeah, we're gonna get up to that part. So the last thing you want to put into the contract, and I'm a believer of this generally in contracts, if you're a good deed doing company, especially if you're on the receiving end of money. And especially if you're up against a large company. Large companies don't like to put that in there because they like to push you around and bully you. But I'm a believer in a loser pays the winner's legal fees in a transaction. And I'm actually going to tell you, I'll just tell you a quick story about.
So you're saying that's one thing you should have.
You should have the loser pays the winner's legal fees in your consignment. I like that provision. Wherever you're in getting the receipt of money, that's a provision I always put in an agreement. And the reason for it is, if you go to court, let's say you're owed $10,000. So the other side of the people who owe the money say, well, if you take me to the court, I'm going to raise this issue and that issue. By the end of the day, you're going to end up spending $50,000 to collect $10,000. So forget about it. So I had a client years ago, a fantastic client who went into a contract with a very well-known accessories company and for very interesting products. They made bags and booties and that looked amazingly like dogs. One of their lines was called Puppy at Heart, and they did an incredible amount of business their first season with a very well-known accessories company. But there were a host of problems that I won't go into, but I made sure this was a license agreement, that they got 2 years of minimum royalties. And this, after 1 year, the other company didn't want to proceed. I had a loser pays the winner's legal fees provision in that. So I collected 80 cents on the dollar in a settlement without having to go to court on that, because I had that provision in there. My client just tell people, Charles Klein saved my business because I had that provision in the contract. And a lot of lawyers will put that in, but you'd be surprised how many lawyers don't. So that's something I always want in a contract.
Actually have that each person pays their own.
That's
legal
right.
fees.
That's right. That's, you know, in the United States, that's the general rule. You know, in England, they have a different process, but in
Litigation.
yeah, in litigation in the United States, each party bears its own cost, except if it's a totally frivolous lawsuit, the judge might award legal fees, which happens sometimes, and you read about in various political cases where that's been in the case. But in our general rule is each party bears its costs. So you want to put that in there. So the next document is the memorandum of consignment we talked about. And the memorandum of consignment could be done as part of the consignment agreement. It could be an attachment to it. It might be included within it. And if you're doing one shipment on consignment, that may be the entire deal when it comes to the memorandum of consignment. But if you're doing multiple shipments of goods on consignment, you're going to do those pursuant to the consignment agreement. But each time you ship, you're going to have a memorandum of consignment signed by both parties. And what does that say? It said it's going to specify all the goods that are getting consigned. It's going to specify the wholesale price for each item of goods, so you know what you're getting paid when that item gets sold to the consumer. It's going to say where the goods are going to be delivered to. And it may well have also, depending on the nature of the goods, a minimum resale price, that you don't want the goods being sold for less than X. And that protects the brand. So here's what we're going to talk about now, which is the part of the story that Karen alluded to. We want to keep the goods out of the hands of the lender if the retailer defaults on its loans. So the lender is probably going to have what we call a general lien, where it's going to have a lien against the merchandise, the receivables, and the proceeds from the sale of that merchandise. And they're going to file themselves a UCC financing statement, which always get filed, by the way, in this principal place of business of the retailer. So if they're located in Texas, and that's where their principal place of business is, you file the UCC-1 with the Secretary of State in the state of Texas. And so the lender will have put the world on notice that we have a security interest in the merchandise and the proceeds, in the receivables of the retail borrower. So you need to know who is out there who has that kind of lien, because that lien, that security interest, unless we follow these procedures, is going to attach to your merchandise and to your proceeds. And if there's a bankruptcy, they're going to take your merchandise and take your proceeds. So how do we get around that? We get around that by following the UCC very strictly. After we file our UCC-1, and this is before you ship any goods, we're going to talk about what you need to do before you ship any goods. You're going to send a notice of that UCC-1 financing statement to the lender. In effect, you're going to tell them, hey, these goods belong to us. The proceeds equal to our wholesale price belong to us. So you, lender, don't lend money to this retailer against my merchandise. Don't think that you're going to get my merchandise if they don't pay you. that the UCC requires that you do that. Because the thought is, otherwise, without that notice, whether it's true or not, the lender may well know that this retailer does a lot of consignment business, and there is an exception if they know that, but you don't really want to have to get into that exception, which deals with factual issues. But I'll just finish my sentence, but then I see you have a question, so we'll get, so you file that notice, and they in effect can't, if they lend, they cannot get your merchandise, they cannot get your proceeds. But if you don't do it, and you should also get a receipt, by the way, you send it by FedEx or registered as certified mail return receipt requested, and you get a receipt that they received it. They can't say we didn't know about it, we didn't receive it, you get that. So that is what keeps your merchandise in good stead. And there are articles written, if you want to go online, and I read both of them, and I spoke to one of the authors who I think I knew from law school. One of them used to be a partner in my firm, about a very big bankruptcy, and this issue arose not in the jewelry context, but in the apparel context. And the wholesalers did not follow this for the most part. It was when the Sports Authority went bust. And the Sports Authority, and this was apparel that was getting consigned, not jewelry. And the people, people are, needless to say, sometimes greedy in this world, and they're going to do as much business as they can without regard to the risks involved. And they had to ask themselves, why is a retailer asking me to provide my goods on a consignment basis? Does it tell me something? Which people ignored. They wanted to get their goods out there, and they got them out there. And nobody, virtually nobody, sent the notice to the lenders. Nobody sent the notice of the UCC filing to the banks, to the lenders of the Sports Authority. So what happened? Those lenders were able to take their goods and the proceeds, and they became a general unsecured creditor in the bankruptcy. Instead of getting all their goods back, they got very small percentages of money owed in the bankruptcy. So that was the biggest story of people who did not follow. And it's a very technical area that a lot of lawyers have never dealt with before, but that case put people in this field on notice, especially that you must send the notice of your UCC and get a receipt for us to the lender who has a lien and all the merchandise and all the receivables and all the proceeds.
How do you even know? Yeah, who the lenders
Uh,
are.
Yeah, well, that's it. You do, I'm sorry, you have to do a UCC search. You have to do a UCC search. If they don't have a UCC filing, then it does, what I'm saying to you is relevant. They don't have a security interest, but I'll just answer the question, then I'll come back to yours, okay? So before you ship your goods, you're going to do what's called a UCC search with a lawyer and a search company, and they're going to churn out for you all the companies that have UCC filings against this retailer. And most of them are going to be companies like yourself. Most of them are going to be companies that are consigning goods to them, but they only have a right to protect their own goods. They don't have a right to receive the receivables for other sales of other companies' merchandise or to receive your merchandise. But the exception to that is you're going to see JP Morgan Chase or some other bank that's lending money to the retailer, and you're going to see a UCC1 filing that's going to say that they have a security interest in all the merchandise of that lender, of that retailer, and all their proceeds and all their accounts receivable. And that's how you know who's out there. If they don't have that, then they don't have a right, then they haven't put the world on notice, including you. But you do a search, excuse me, simple to do, inexpensive to do. You do it with a lawyer. You can look at the search. You can have the lawyer share with you all the results of that search. You can see all the UCCs that have been filed, see ones that have been filed against the retailer, and go through it and see who they are. And that's how you know who they are.
So it's like a title search, but the law firm does it?
Yeah, the law firm does. It's not a title, but it's in that sense. In that sense, yes, it's a search that's done. And so again, a title search is done in real properties. You're seeing whether you're really seeing. It's a little different because you're seeing ownership in a title search. Who owns the property?
like-
So here it's who has an interest. We call a security interest in assets of the retailer. So, but it's like that in the sense that you have to do it, someone is searching the records to determine that, but in a different setting.
Where is it filed?
It's filed in the Secretary of State, filed in the Secretary of State of the state in which the retailer is located typically. But but when you speak to the search company, you're going to tell them, this is where I'm going to look for. If you think, it also could be, and there's maybe in the state of incorporations, you may want to do it there as well. So to be extra careful. Let's say they're based in Texas, as I said, in Dallas, but let's say they're incorporated in Delaware. You may want to do a search in Delaware as well. And good questions. You may want to search both places. And this is very minor expenses going on for this, by the way.
So the other question I have is if the lender, you're filing this and when the lender gives a loan to the retailer,
Yes.
is it based on their assets? And so they're claiming that your consignment is part of their assets. Say you have 50,000 in inventory that you're giving them. They're claiming that as part of theirs and you want to make sure that it's not, right?
That's correct.
Okay.
Because remember, they're not calling you out. They're just
Yeah.
putting it, you understand that they're putting in their security interest in their UCC, all merchandise, all goods, all sales proceeds, all receivables. So it refers to everything, basically all the property of the retailer,
Mhm.
of this kind of property.
But
So
it's
yeah,
not.
yes. What's that?
But it's not theirs because they're getting capital on what they could be looking to do is get capital, get a loan on by claiming your property as part of their inventory.
But remember,
Yeah.
but that's why you want to put the lender on notice. Don't lend against this money, against this property, because it belongs to me.
You
It's
want
my
it to be-
property. Don't put it in the base of the assets of the retailer, because you're not going to be able to take this over if they default. That's the notion of trying to create some fairness and separation
Mhm.
between the lender's rights to be able to be made whole, but on the other hand, protecting the rights of the consignor, of the wholesaler consignor, who's only giving the goods for sale, but retains ownership. So that's what this technical, precise process is trying to accomplish, to protect the rights of both parties. And the other thing that's important is that you go through this entire process before you ship any merchandise on consignment to that retailer. Because if you ship the merchandise, that's going to end up, even if you do it afterwards, it's not going to protect you for the merchandise that you already shipped, because you didn't put them on notice before you shipped it that this belonged to you.
What's the typical amount, say, a mid-level retailer, wholesaler would ship? Is there a certain number that you think is, like, say you have 30,000 to 50,000 in inventory? Is there, like, do
I can-
I know it's
I
a
can't
vague
really answer.
question.
No, I can't really answer that. But I think it's really more of a business question. But again,
Yeah.
if you're following this process, you should be protected. But again, do you want to go, if you think they're going to be financially troubled, do you even want to get into this process? Do you want to risk your goods? Do you want to have a fight over it, even if you're going to win at the end of the day? So that's a question you have to ask. But different companies have different risk tolerances for just shipping consigned merchandise. And as we speak, and it's different because there are no UCC1 filings there. I have a client that's actually based abroad, even though they're based both abroad and in the US, and they're a fine jewelry company, and they're consigning goods to a small group of high-end retail stores in France. And I'm working with French counsel on that. But there's no UCC there. There are no searches there. But so it's a different set of rules. But those are good questions. No.
The UCC1, if I'm based in New York, but I'm selling product to Texas, do I have to file both one in New York and in Texas?
No,
Just one.
you just have to file it in where the principal place of business
You have to file it in Texas,
in Texas.
even though
Yeah, it's not your state. Yes, it's in Texas. It's in Texas because you want people who are doing business with the retailer to know this, not to know. No one's going to do a search for you. The vendors, the wholesalers are going to be located all over, the country. You know, that the issue is where the retailer is located. But again, I said, you know, in response to the question before, that you may want to file it also in the state of where they're incorporated. So you may want to file it both in Delaware, if they're incorporated in Delaware, or some other state other than where their principal place of business is, to file it in both, the Secretary of State in both locations. Any questions?
I have lots of questions, but I'm gonna wait till you're done because I'm trying to stay on
Yeah, I know I can
track. Yeah, I can, yeah.
Okay. Well, that's really, that concludes my presentation here. But the other thing I'm going to say to you is, you know, I'm happy to give you my card, needless to say. And if you have questions afterwards, feel free to get in touch with me. If I can help you, feel free to get in touch with me. My direct dial number is 646-428-3240, 646-428-3240. My email address is ck@dhclegal.com. And just so you know, I began my career, and I'm writing a series of articles about this, really more in the fashion side of the business. But I've been doing a lot in the last year and a half, last 2 years, in the jewelry side of the business in a variety of ways. And I thought about this, and the jewelry is sort of in my blood. You know, the apparel industry was not in my blood, but my dad throughout his entire life was a polisher of gold jewelry on 47th Street. And I would go there, I think, as a kid, and once a year, I and another employee's sons would go there and sort out charms. It was a charm house, gold charm house. So I always had a sort of a close affinity for the jewelry industry, which I think has I've returned to my roots.
Well, so one of my questions, and interesting enough, the ladies on the phone aren't in jewelry space. They're in leather goods, either footwear or handbags. So my first question has to do with damages. So like Alexis has these beautiful shoes that are fragile. I mean, if they're just thrown on a rack and she gets a garbage back in a box, what happens?
Well, they have to, the agreement should say that they're going to maintain the goods in safe and clean condition. And remember, also they're insuring the goods, but it says that the goods have to be maintained in safe and clean condition. The other thought is, again, it's a very good question. Jewelry normally is not going to be used in such a way as to affect, you know, the jewelry itself. But, you know, clothing or bags or shoes could be. So I think you have to ask a question. Do you know, if people are going to be trying on this merchandise, do you want to get that back? Do you want to consign that kind of product?
What, you have to try on a shoe. A
That's right,
bag,
that's
you're
right.
gonna pick it up, touch it and feel it,
Right.
but
But a shoe,
Yeah.
I would be hesitant about consigning footwear. That's just me, but I'm not in the business. I mean, I think any merchandise, you want to be sure that you're going to get the goods back in safe and clean and resellable condition. And I think with wearable products, not jewelry, but, you know, clothing or accessories products that are more wearable, there might be more issues with that.
Well, right now, Alexis has an opportunity to consign her goods in a high-end store in California. She's in Italy right now. How could she protect herself?
The only way she can is following the process we discussed, but also putting in, making sure that the goods are insured, but then you still may have an issue when they come back. Is it that they're not totally ripped, but they're not in the kind of new condition where you could resell it to a consumer? You know, they're also in the apparel space, you deal with some of the issues that just happen with returns. You know, people get the goods back, you sell it, and the goods are returned, and, you know, they're not in the same condition. People have tried them on. You know, there are people who have businesses sort of refreshing goods for resale, you know, today with large returns of goods. But I'd be more hesitant in that process, you know.
What are the
Can I ask a quick question?
Yeah.
Sure.
Thanks. So, Charles, my question is this: you write this agreement and you say that, you have to keep the goods in a safe and clean environment and et cetera, everything you mentioned. They sign it. Is that what you're asking? That we sign it? They sign it?
Absolutely, yes.
Okay. and then it's technically legally binding, but again, if it comes back and it's damaged, if you would have to sue, right? Or you'd have to
That's
fight,
correct.
right?
That's
You're gonna
correct.
get into
That
a
is
whole thing.
correct.
Okay. So
That
you
is
hope
correct.
that everybody keeps their end of the bargain.
Right, that you're dealing with you're dealing with lawyers would call a factual issue.
Yeah,
You know, he said, she said, are they in good? And you take pictures when they take pictures of them before you send them out. You take pictures of them when you
Yeah.
get them back, you know, and then you're dealing with, you know, little finite issues. Is it, can
Right.
you sell this? And they say, oh, it's, to me, it looks good. You know, you're dealing with
Yeah.
factual
It's
issues.
a little gray. Yeah.
Yes.
And then my second question is, you mentioned returns. That's actually really interesting. Can you put something in the agreement that says basically once it's sold, they need to pay for it, and any returns, they need to just keep the merchant, like,
No, no, you're going to put in the agreement.
yeah,
The first, one of the key first clauses that I mentioned, you're going to put in the agreement that when they sell the goods,
yep,
they pay you.
they pay me. But right, but now it's returned. 2 days later, somebody,
That's their problem.
that's
They
their
own,
problem,
they
right?
own the goods.
Yeah,
They
so you
own
have
the
to make sure
goods.
that they, once it's sold, they own it.
That's right, because they own the merchandise when the goods, they own the merchandise when the goods are sold, because they have to be able to sell it. You're not
Yeah,
making the sale, they're making
understood.
the sale. So they own.
And I would
they-
put a caveat in about that
Yeah,
returns.
so you have to that's a good point. You should make that clear. I
Okay,
agree with that.
thank you.
Retail theft is so prevalent right now. What happens if the bags are stolen or goods are lost, you know?
You know, you get it, you know, again, they should have insurance that you're gonna be against, that covers theft as well. And then
The retailer, or do you have your own
the retailer.
insurance?
And if you can get insured for it as well and put these goods on your policy to cover that, that's good as well. The retailer should have, you know, a theft policy that you can get coverage on. You know, the issue, then you get into what are the limits of that insurance. And if they have multiple parties and multiple vendors, or there's some, you know, casualty that happens, there's a flood, something does, and it's not just your goods, but other people's goods, you know, is their insurance going to cover all of that? So there are risks involved, you know, in this process, you know.
So how do you know the health of the store? Like, you know, okay, we'll pick on Barney's. Like, we all knew Barney's was a sinking ship, right? But people still ship to Barney's. Saks is, everybody's got Saks on notice. They're paying slow. How do you know the health of a smaller store where it's not so publicly talked about?
You may not, you may not know that. But
But I would
again,
assume that UCC search will be a hint, right?
no,
No?
it's not. So let's go over that just because it's, I know these are very technical issues. So let's go remember what we're trying to accomplish here.
Okay.
What we're trying to accomplish is that if they default on their loan, that your merchandise still belongs to you and you can get it back, and you can get any proceeds equal to your wholesale prices as well. So that's, it's not saying the UCC search is just telling you who is out there, what lender or lenders are out there that have liens against all merchandise or merchandise.
And that's not a hint or whatever that of whether they're healthy or not.
No,
'Cause
it's not, because everybody has a lender, you know,
Got
but
it.
people are borrowing money to, you know, operate their basic business. So again, it's like
Understood.
doing business with, even if you're selling goods outright and you're not getting paid immediately, you know, to try to know what is the scuttlebutt in the industry, you know, and there are factors and banks here who deal with these issues, and they tend to hear, you know, what they hear on the ground as to health or not, but nobody really knows that. It was just hear scuttlebutt, you know, and when you hear that someone might be troubled, and as you said, people were still shipping. Look, people shipped, I told you, people shipped an enormous amount of goods to the Sports Authority and didn't question why is this chain, you know, asking for consignment goods in the apparel space. People wanted to ship, they wanted to do business, they wanted to sell merchandise, and so they did it.
And is a trunk show the same rules as a consignment deal?
Well, I'm not.
Isn't it technically consignment if I'm doing a trunk show?
No. Typically, and I really have not dealt with it, and I've had clients, you know, say who've done trunk shows. But normally my experience is a client is taking merchandise to a trunk show, to various retail locations, and they're selling where they can that merchandise on the spot, and somebody is paying for that merchandise on the spot, just as they would to walk into a store and buy something off the rack or in a jewelry case or whatever. So that's not a consignment issue. You're holding, you as the wholesaler or designer, you're bringing that merchandise. It's yours, you're holding on to it, and you're selling it directly there. And I've not got involved in sort of the nitty-gritty of how the trunk show sales work. You know, my clients have done it over the years, and that's something they handle on their own, but it's not a consignment.
Okay.
In terms of when you're shipping your goods to a retailer that are consigned, the insurance is on you for the shipping until they.
That's
receive it,
right. That's right. That's
But
right.
now, if they're shipping it back, you have to put that in the
You
agreement.
usually the deal is when they ship it back to you, you also
Pay.
you pay the freight and you're
You
insured
pay
for its
for it.
return both ways. Yes.
And,
It's a good-
Diane, are you
that's a-
paying freight both ways?
Take myself off mute. No, so far the retailers have paid to ship it and will pay to ship it back. So we're splitting it,
Well, that's good.
and then do you have examples?
or
of-
vice versa. Sorry, I apologize.
Well, you can go online. You know, I don't really give my agreements out.
No,
Is it-
but if there's a good place for somebody to go to look at it.
You could go, you know, here's what I would say to you. It's like with any other contract. You can get a sort of a general idea if you look online for a form consignment agreement, what they might look like. Is that necessarily a good one? Maybe, maybe not. It'll give you some idea of what they are, what they look like. But again, you know, I don't recommend do it yourself, just me speaking as a lawyer, you know. But you can go online and just, you know, look for consignment agreement forms and you'll see some.
I would say though, if you have expensive goods, you don't want to screw around with Rocket Lawyer.
Yeah.
No, you have,
You know,
I personally don't believe in that, you know, in general. It's just my own view is that I think every situation is different. It's not going to be tailored enough to your particular deal and your needs. So I don't believe in sort of the online lawyering systems. I think also the relationship between, you know, lawyer and client, the kinds of very particular issues that arise in your situation, your particular concerns, the kind of things that we talk about. I'm going to mention one other thing to you that I've been thinking about because I'm doing a new article about I do a lot of work in the licensing field. That's what if you see, you don't, even though I don't like to be pigeonholed, if people would say, what is Charles Klein? They'll say he's a licensing lawyer, but it's not really true, but it's been a significant part of my practice. But I had a client many years ago who had passed away in her mid-90s, who I loved dearly, who had a very well-known, mainly men's sweater business. Her name was Cecile Platofsky. She had a business called Trico San Rafael. And she would say to me, and this was before the internet, and when I still had a lot of, before Zoom, needless to say, a lot of telephone conferences with my clients. And my office is where it is today at 39th and 3rd. And she was up on 55th and 6th, would have to go across town and then up to her office by a taxi. And I would say to her, let's talk on the phone. And she would say to me, Charles, you have to come up to the office. And I loved seeing her, but I said, got to go up to her office. And you know what? She was absolutely right. Even with the Zoom, things come out in personal communications. There's just something about human in-person communications where it prompts certain kinds of communications that don't come out otherwise. They certainly don't come out in emails, they don't come out in texts, but maybe that follow-up question that spurred from a human contact, she was right every single time. So it's happening less and less, needless to say, but there is some value of anything important. I still believe in it. And I don't believe in for that particular reason, because I still think that personal aspects, questions you may have, question that you may think is a silly question. I always say to people, there are no foolish questions. You always have questions, and there is no such thing as a foolish question. You ask, you don't know until you get an answer, and you talk it through. So that process is very important. And I always tell clients, you know, you're going to always know more about your business than I do, no matter what. So even though I've been around for a long time and I've worked on a lot of matters and deals, you're always going to know more about your business than I do. So I like to have that interchanging process. I like involve clients, you know, because I'm going to learn from them. I'm going to be able to protect them better when I know their goals. I know how their business works, and that's, you know, that's worked very well for me over the years.
So is it possible, like Diane, and I'm gonna pick on you because I know that you have a number of consignment options at this moment. So she should maybe have could she have one standard agreement that gets tweaked? So
Yeah,
invest in
yes,
that.
That
yes.
is what we've done. Yeah, that is what we've done.
Yes,
Yeah.
I agree with you. If you're able to do that and you're doing with specialty stores and you're not
Yeah.
dealing with that.
We are only
Absolutely.
specialty. Yeah.
You have your form consignment agreement and you
Yeah.
tweak it as necessary.
Yeah.
And you may have the other side may have different comments when they come back to you, but
Yep.
your form for
Yep.
sure.
Yeah, I 100% agree with that comment you made earlier. Like, we need to own that and control that to the best of our ability and not let them create what that looks like. So yes, we have
Absolutely.
a form that we've been using.
I'm going to tell you one. I'm a storyteller. Sorry, I think everything's a story. So in my next, I'm going to talk about the other thing I'm going to say to you. In general, I think it's a good life lesson. It did not come from the fashion world, the jewelry world, but there was a legendary college basketball coach named John Wooden. He was the coach of UCLA in its heyday. Bill Walton, Kareem Abdul-Jabbar, 11 NCAA championships. He was a very wise man, and not just about basketball, about life in general. And he had an expression, a saying, which I think is even more true today. And that was, be quick, but don't rush. Be quick, but don't rush. And from the basketball standpoint, he meant, don't dilly-dally. You try to make that pass as quick as you can, but don't rush the pass, because if you don't look carefully, the other team is going to intercept your pass. So in today's world, a lot of people think speed is everything. No, it is not. It is important. Don't dilly-dally. Work very promptly. But I'm going to talk about in my next issue, two different circumstances. One, the quickest license agreement I ever did. That was done from start to finish in 7 business days. For I'll call it a minor celebrity. It was on the other side. And I also controlled the document. The reason I was able to get it done in those 7 days, this is something important that clients don't always know, who the lawyer on the other side is. Their background, their experience, how reasonable or not they are, can affect your transaction in a major way. And I had a very inexperienced, good lawyer, but a music lawyer, knew nothing about fashion licensing. And he was a nice guy and a smart guy, and he was a cooperative guy. So I was able to get it done in 7 business days from start to finish. And the client was super happy. They got to the magic show. They had a booth at the magic show, which they never would have gotten done if we didn't do it fast. The other one was in sort of this space, a very unique space, where my client had come out of the jewelry industry and they were in the decorative home product area. And it took us a year and a half to get this agreement done. But he was already working for this company. He was their design director, and they already were using his brand, but they woke up to the fact that they had no license for it, and they had no legal right to use it, actually. And I created a license arrangement that was very unique for him to encourage these people to do this with him. And they were located in Rhode Island, where I know there are a lot of jewelry companies. It was Cranston, Rhode Island. And we met, so they were tough, very good business people, but tough people. We met in New Haven twice during this, in midway between. We got it done, and his income sextupled as a result of this transaction. He ended up making $1 million a year because we were patient, but we got it done. And so most of my transactions don't get done in 7 days in the licensing world, and they don't take a year and a half to get done either, but they all have their own sort of life and their own particular circumstances. So say, be quick and don't rush, be persistent, be prompt, be responsive, think things through, and just do that in a professional way. Sorry to go off the topic, but I thought those sort of sometimes general issues might serve you well and other matters you deal with.
What about time frame? What's the typical time frame where you would consign something before you take it back? Is there
I
a
think
deadline?
that's really just case by case, you know, I mean, that's up to you and the retailer. But it's a good question. It might be for a season, depending on the nature of the goods. It might be for the season. It might be for the fall season that they want it out there. You know, that's something for you to work out, you know, and they may say, you might actually put the dates in there that it's going to be through that period. But, you know, I like to, if I can, I like to have the flexibility to take the goods back. They may not be selling well, so it might actually want those goods. Another retailer may want them, so you could get them back and sell them to them on an outright basis.
I think that's important what you said about making sure that they give you a report. Because if your goods are sitting in somebody's store, and if you don't get a weekly report, if they're not moving them at all,
Mhm.
then you may not even get those goods back until it's too late.
Right, you want to get a period, you want to get a periodic report.
You should definitely have some kind of sales report.
Absolutely, but you're not going to be able to, you want to know what's been sold so you can get paid. You know, you need that, you know.
But if it's not selling, can you also request images of where the product is in the store? And
You can, you know, here's one other thing that we're dealing with this French company. You know, their insurance policy requires, because it's, you know, fine jewelry, that it be stored in certain ways. So we're putting into the agreement that we have the right to inspect. You know, look, you can't fully control it, but inspect in the stores how the jewelry is being displayed, so it would satisfy the requirements of the insurance policy. Not that it's, you know, not being handled properly. I'm sure they would do that anyway, but you never know. So yes, you should have the right to inspect it if it's that kind of merchandise, and you want to make sure the insurance policy is going to be honored. Absolutely.
Diane, Alexis, any other questions?
If we could go back to a point that was made earlier about the merchandise being kept by the retailer in sellable, clean condition. You know, I'm being a shoe designer, and I've seen this sort of done with other brands and I guess let me make the example first. The shoe brand Tamara Mellon, when she sells her shoes, she has like this plastic sticker on the bottom of the sole so that you can try them on without ruining the soles. And I guess if you don't want them, you can return them. But that is for her online business. I believe she's online only now. Now, in my case, if I'm consigning in a store and I want to keep the soles clean or pristine, would it be? I guess I could put as a stipulation in the contract to ask the store to have customers try the shoes on a carpet. Would that be something strange?
Well, there's nothing wrong with putting that in there. You know, the problem, you know, you're not going to be able to see the way each customer wears it,
Right.
they walk with it. The bottom line really is that, and I'm sure they would generally do that with their shoes, because they don't want their shoes being used when the customer doesn't buy them, having the shoes become unsaleable because they don't look like new shoes. So, you know, I think that's sort of a given, but there's no reason not to put it in there. But at the end of the day, the real bottom line question is, when it comes back to you, is it going to come back to you in new condition that's going to permit you to resell them, whether that's in your contract or not? And, you know, you have legal issues. So, you know, I don't know how much goods you're going to consign. Are you going to sue them over, you know, $2,000 of shoes that, you know, where it looks like they may not be new, and you're going to go into small claims court about that somewhere? You know, you have, you know, sort of difficult fact issues to deal with in that regard.
Okay, but essentially I could write something in the contract suggesting that.
You could, but at the end of the day, to me, it's less of a contractual provision, because at the end of the day, whether you put that in there, you're not going to be able, they're not going to take a picture of every consumer
Right.
trying on your shoes and you say, whoa, look, Judy Jones was walking on the hard floor there. She didn't comply with the contract. You let her do that. At the end of the day, it's really what condition they came back.
Right, okay.
Because again, you want to make this workable. I mean, if you want to do this, I think to my mind, with all these kinds of clothes, jewelry is one thing. To me, in jewelry, it's easier to do because you're talking about, products that are not going to be harmed in the way that, apparel or footwear could be. Or maybe bags. I'm not sure. I think bags, again, maybe sort of a middle ground. I don't see that as certainly not as risky as footwear, maybe not as risky as some other clothing products. But jewelry is at one end where I think it's the best candidate within the consumer's product space for consignments, and the others, I mean, footwear may be for the reason all these issues we're talking about might be at the other end where it is fraught with risk, I think, in consigning footwear.
Risk reward.
Do people ever negotiate like a percentage where, just, because you're going through so much trouble of going through this and you don't want to get so much merchandise back, could you negotiate that within this period of time, this much could be sold, otherwise you assume ownership? Could there be a clause?
You could. I mean, I don't think people normally want to do that. Retailers, it's not common to say, look, at the end of the day, if I'm going to make these goods, maybe they're specially made for you, that I want to know that 25% of this is going to get sold. At the end of the day, regardless of what is sold, you're going to pay me X dollars.
Yeah,
You could put that in there.
If you really want it.
You could put that in. One other clause we haven't talked about because it's more complicated. I've seen it in the jewelry space with some of the department stores, but this is not the same as what you're talking about. Have done separate agreements as part of this transaction where they're advancing monies against the consigned goods, but they're still not guaranteeing the payment. But it's putting some money into where they have a relationship and they know that these goods will ultimately sell over some period of time. They advance some of the monies. There's a separate advance agreement that is done with some of the luxury retailers to accomplish that fact. So it puts some of the money back into the jewelry company while this process is going
I
on.
just feel like if there's a shared risk, there's a motivation to sell it versus if there's no shared risk, the stuff is just going back.
Well, this is true, but
But I
they don't
mean-
like sharing the risk. That's the whole point. They do it, but look, that's something. It's a creative thought. It's a creative thought that for me to say, you know what, I'm willing to take a lot of the risk, but I want to know at the end of the day that at least you're going to pay me at least X dollars, and if you're not prepared to do that, I don't want to go through that process. So that's an interesting clause.
But I also think, part of the shared risk idea is like you as a manufacturer or seller to the other business, it's just as if you were selling to the consumer, you have to make them want your merchandise and do a good job saying, hey, listen, I've been pushing it here and here and here. And if you really want it, because I mean, even if you want to get rid of it, you need to sell your product, right? So if you really want it, I'm willing to sell it to you instead of like, I need you to sell it for me. I'm willing to sell it to you, but there has to be a shared risk because I have other people asking for it.
I'm willing to consign it to you, but
Consign it.
could consign it to you,
But-
it has to be some shared risk. It's an interesting thought. Okay.
Create some FOMO.
Are retailers going to do that? I can't answer that. Probably
Try it.
not. But it will obviously, it depends on your market power. If they really like the goods, you'd still would ask, well, why aren't they just buying them outright from you? But if they really like the goods and it's a good brand and they really want to have them, it's an interesting thought to say, you know what, at the end of the day, you're gonna pay me X no matter what, as a get for these 25% of the consign for 25% of the wholesale price of the consigned merchandise. That way I know that you're really trying to sell. So it's an interesting idea.
Yeah, I mean, as a business person, you're ultimately in sales, you may be making beautiful product, but don't forget, you have to sell the product in order to make a living. So I would always like try to create some sort of FOMO around it. Like, it's like the #1 rule in sales. If they feel that other people are buying it, they'll feel they can sell it, but you want to get it out and you don't want that stuff back, you know? So, I mean, it might be somebody you want, it has to be a relationship that'll work. You don't want to sell it and it's going to sit there. I wouldn't even consign it in that situation, because then you're just doing half of the stuff just to get it back. But if you feel that, you know, if you both feel it can work and it is going to sell, then I would ask at least. It doesn't cost anything to.
In general, I agree with you. It doesn't cost to ask. I have clients that are afraid to ask things, and if you don't ask, you don't get. So I agree with that thought. It's a creative idea, and I think it has to do with the market power of the
Yeah.
wholesaler.
Yeah, and I would just add, as a startup, we're doing consignment as a way to get started and a way to get into a few retailers and learn and see what's going to sell and what's not going to sell, and to make it easy for them to give us that opportunity. Our ultimate goal is not to be on consignment forever at all. Ultimately, we would like them to purchase up front. We want to have that power to have the name known, et cetera, and have, actual sales that we can talk about. So, I think we all know consignment's not probably the be all end all, but if you're doing it for even a short period of time, I felt that this was very helpful, Charles, just to make sure we were thinking through all the things we want to have in our agreement.
Well,
And the whole concept of making sure you
ask,
understand who the lenders are and all of
I'm
that.
going to ask you a question.
Yeah,
In that thought process, because
Yeah.
obviously, as I said, first of all, look, like you said, you're a startup now, although it's a well-known brand. It gets your goods out in the marketplace. It's helping you launch this, getting the consumer as well as the other retailers aware of your presence, of your good
Correct.
products that you're making. But here's the other thing, and it's just another sort of life lesson. And starting on a consignment basis, do you have any concern that having started on that basis, that you've gone down a path with these retailers, that's what they're going to expect of you?
Yeah, I'm not, because we've basically also said, if you find out that these sell and are doing well for you, then the next option is, if you could purchase, and I know you said don't put it in the agreement, but they can purchase what's left over after this certain amount of time, or anything going forward. We'll look to make that a upfront purchase agreement. And at that point, they'll have faith that they can sell the goods and they'll know which styles sold, which colors sold, et cetera. So, I'm not overly concerned that we'll make that the only way that they'll do business with us.
Well, the reason I've asked that, and it's just a question, because you're the business person, I'm just a lawyer. So the reason I ask that is, my understanding was that in the jewelry space, that this whole consignment area arose, in particular during the 2007, 2008 financial crisis, when business was really tough. And the retailers did not want to take on product otherwise, but it became sort of a part of the permanent landscape to a large degree, not the total picture. That the only reason I ask that is, when you start going down the consignment road, and obviously, like I said, in the jewelry field, it's just part of the landscape and it's just the way it is. And
Yeah,
just try to get goods. Both.
When I first started working, and I was working for Macy's, and this was a long, long time ago, the entire jewelry business was consignment for Macy's. So jewelry has that historical background of doing
Right.
that for whatever
Right.
reason. There's so many SKUs, and it's just, there's so much that you have to carry. And so I think it's slightly different. Having said that, I agree with you, retailers like it, right? Because they don't have to buy it up front. But I think it is a business way, the way you work the business and the conversation you have with the retailers and the trust that you build. And we're going to look to convert from consignment to purchasing up front. And I agree, there's some unknowns. We don't know for sure. We're still really new, but that's the plan.
I got it.
I think, Diane, too, it got you into a few stores, so it's a marketing expense and risk more than it is a sales story.
Yeah,
because
and to your point, Karen, we're in 12 stores now. I think maybe we're going to be in 15 shortly, and we've kind of said that's it. Like, we're going to wait now and see what happens. So,
Well, Karen, if you remember early on at QVC, all of our footwear was on consignment.
Right.
And it was an accounting nightmare, and we moved from consignment to sale and return, where QVC actually bought the goods up front, but we could return them, and we had it. We had to
Right.
hold back because it was a little bit cleaner.
Right. Well, okay, so I am I'll connect all of you to Charles, so you have his information. So if you have any other questions or you need help, you can reach out. Again, my experience with Charles is he's a wealth of information in, as he mentioned, in licensing, but his firm has a number of other specialties that we've valued greatly.
We're a what I like to say about my firm, we're a medium-sized firm. So we're small enough to handle even small clients, and we're big enough to handle major companies. So I like our size. But also I want to thank you for all your insightful questions and comments. You know, I always learn more from your discussions, and your people are clearly knowledgeable people from this industry. So thank you for coming, and thank you for sharing your questions and comments with me. Any way I could help you and your clients or friends or your company in the future is my absolute pleasure.
Great. Thank you, ladies.
Thank you.
Thank you.
Talk to you soon, okay?
Thanks very much.
Thank you.
Thanks.